Yes, Justice Thomas, and turning back to the response I was giving to Justice Barrett earlier, there is, I think it's very well set out in Professor Baumsei's amicus brief, there is this history of presidents using a tariffing power or a tariff equivalent power, very, very close to tariffing power, in wartime to tariff trading with enemies. And that is when the Trading with the Enemy Act was enacted in 1917, it was deliberately evoking that. And when it brings in the power to regulate importation, it's essentially codifying for an inherent power the president's already recognized to have. And then in 1933, when that power is expanded to an area where he wouldn't inherently have it, the peacetime context, that codification, the meaning of that remains the same.
The other side is going to argue, make an argue on delegation, I believe. Would you anticipate that and give us your understanding of the delegation argument?
Yes, Justice Thomas. I'd say a couple things in response to that. First of all, this court has stated that the non-delegation doctrine does not apply with anything like the same force as it does in the domestic context in the foreign context. And that, again, to cite Dames and Moore again, Dames and Moore cites Youngstown, and Youngstown in footnote 2 of Justice Jackson's opinion, he goes into detail about this. He addresses Curtis Wright. He says there's a lot of broad dicta in Curtis Wright, but the holding of Curtis Wright, the ratio dissidenti, is that the domestic non-delegation doctrine does not apply with the same force in the foreign context. And then he uses that phrase, does not apply. He says the strict limitations on delegation that apply, in the internal context do not apply in the external context. And so we rely on that line of cases. And for the reasons I talked about earlier, where we're talking about a situation where the president has his own inherent authority to address foreign arising emergencies, and Congress is conferring tools on him that expand his ability, his capacity to do so, we are in the area of Youngstown Zone 1.
A few times you have alluded to the history as being important in interpreting the statute, and also that this language comes from the Trading with the Enemies Act, and that has its own pedigree. Could you just sketch out this direct line that you were alluding to as a basis for interpreting the current emergency statute as you would like it interpreted?
Yes, Justice Thomas, and turning back to the response I was giving to Justice Barrett earlier, there is, I think it's very well set out in Professor Baumsei's amicus brief, there is this history of presidents using a tariffing power or a tariff equivalent power, very, very close to tariffing power, in wartime to tariff trading with enemies. And that is when the Trading with the Enemy Act was enacted in 1917, it was deliberately evoking that. And when it brings in the power to regulate importation, it's essentially codifying for an inherent power the president's already recognized to have. And then in 1933, when that power is expanded to an area where he wouldn't inherently have it, the peacetime context, that codification, the meaning of that remains the same. The regulate importation language that's brought in from TWIA and then ultimately to IEPA in 1977 is carrying with it that connotation, and that's reinforced by all the cases we cited in our brief where there's been extremely broad delegations of the power to tariff specifically and the power to regulate foreign commerce more generally, going back to the time of the founding, which ties to your question about non-delegation.
Justice Alito?
The court of the CCPA said things in Yoshida that are helpful to your position, but it also said some other things. It said that future surcharges, quote, must of course comply with Section 122 of the Trade Act of 1974, and it said that the Trading with the Enemy Act did not authorize the president to, quote, fix rates of duty at will without regard to statutory rates prescribed by Congress. So do you think that Congress, to the extent Congress had that decision in mind and relied on it, do you think it also relied on those statements in the opinion?
Not in the same way, because those statements are read into other provisions of TWIA that Congress did not enact in ANIPA. They may still be there in TWIA, but those are limitations that it wouldn't make sense to do. And I think the significance of Yoshida is at a higher level. Keep in mind that their principal position is no tariffs at all. Regulated importation just doesn't carry a connotation of the power to tariff. And we say we've got historical sources going back to Gibbons against Ogden that say the opposite, but more fundamentally, everyone knew that at the time IEPA was enacted that regulated importation had just very visibly and very prominently been upheld to include a sweeping global tariff.
Thank you.
Justice Sotomayor?
I'd like to go back to Justice Barrett's question on the word license as used in AIPA. It's not used as a verb, it's used as a noun. The President may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, then do what the verbs permit him to do. By license, he can nullify, void, prevent, or prohibit any acquisition, etc. So license is not being used as a verb that through licensing he can raise revenue. He can only use licenses to accomplish the verbs. So I don't understand how we can treat licensing as equivalent to revenue raising. As used in AIPA, the license is only to accomplish what B permits.
In Hamilton against Dillon, licenses, once you had the license, then you had to pay the fees, the license fees to get it in, and those are
But that's the point I'm
economic
making, which is that the only use of license here is a noun. You can license to accomplish the powers that B gives the president.
Let me be clear. We rely on the phrase regulate importation. We're not saying that
Exactly. You're not relying on licenses for that reason.
No, I only cite that language, that introductory language about, instruments, licenses,
That
or
you
otherwise
can't rely on
as
revenue.
another layer of breadth in this particular
Counsel,
statute.
would you listen to my question? You're not relying on license for the reason I just said, because it is a noun, not the verb. You're relying on regulate, correct?
Yes, we're relying on regulate importation.
And despite the fact that no other president in the history of AIPA has ever used tariffs as a power under AIPA.
Well, President Nixon did so
Under a predecessor, and we have all the limitations of that. All right. Number two, whenever Congress intends to permit taxing and regulate, it uses the word tax and regulate in every other statute, correct?
I don't concede that. I mean, two very visible examples, again, are TWIA and Section 122.
We're back to the question here. Okay. Thank you, Counsel.
Justice Sotomayor?
No, she's Justice Sotomayor. She just finished.
Justice Kagan?
General
And
Sauer.
they're friends?
I want to take you back to Justice Thomas's question about non-delegation. And if I understood your answer correctly, it was really similar to the answer that you started off with when you talked with Justice Thomas about the major questions doctrine, which is sort of everything's different because the president has independent constitutional powers in this area. And so that if one does not think that with respect to tariffs, if one thinks that a tariff is a taxing power, is a regulation of foreign commerce that is really delegated by the Constitution to Congress, that argument does not sound so well. And in fact, when you look at J.W. Hampton, which gives rise to the non-delegation test that we usually use, J.W. Hampton is a tariffs case. And the court did not say, oh, we need some special new principle here, some stricter rule because we're dealing with tariffs in which presidents are directly concerned as a matter of foreign relations. It enunciated the test we use for all non-delegations. So how does that fit with your theory?
8 years later, in Curtis Wright, the court held the non-delegation doctrine for domestic affairs does not apply with the same force.